The Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we call the case, just a couple of things. If things have been running very smoothly as far as technology goes, but if we should have any problems, don't worry about it. Just if you have something, if one of us freezes up for you, let us know as soon as you can. And if we have some difficulty, we'll work through it and get it going back again. Call the case, please.
Sara Marie Poe Mossbeck versus John Pollard Hoover, Jr.
We'll hear from the appellant.
And on behalf of John Hoover, John Konvalinka, with regard to the issues in this case, they stem or arise out of the relationship among mother, father, and daughter. Beginning in October of 2014, there was an order entered by the court, which was non-protunct to October 3 of 2014, with regard to the parents being obligated to consult and discuss whether there was what inpatient residential treatment was to be provided in the event that outpatient treatment of the child was not successful. Unfortunately, later on in October of 2014, and I should back up and say, not only were the parents and the child involved, there was a guardian ad litem, a lady by the name of Kathy Raoul, that was also involved in these discussions at this time, and she later withdrew in 2016. In October 2014, it was decided that the daughter should go to inpatient residential treatment. There is a dispute as to what occurred, in the sense that my client says it was discussed among him, the guardian ad litem, and the mother of the child. The mother of the child consented and signed patient authorizations and consents to treatment, but did not sign a promise to pay in connection with the information packet or document packet that was forwarded by the inpatient residential treatment facility. Needless to say, my client ended up paying what was not covered by insurance from the year 2014 and some portion of 2015. In 2015, he began texting the mother of the child, asking for her insurance information so he could submit it to insurance. He says he did not receive a reply, and there is no written documents to the reply. The mother's contention at this time is that he was given that information sometime in the year 2014 and he should have it. Well, needless to say, they exchanged a number of texts, which are exhibits 3 through 7 of this trial proceeding. In connection with that, the portion of those two exhibits, the number 6 and 7, I believe, are my correspondence, in fact, to the attorney who then represented the mother, which was Misty Harris, in which I was again advising her as to what was owed and what was being incurred, and that there would be substantial more bills still incurring. I never received a response to that, other than Ms. Harris did ultimately file a motion to withdraw. The mother never responded to any of that. Interestingly, in some time, unbeknownst to the father and unbeknownst to his counsel, the mother did submit information to Blue Cross Blue Shield sometime in the year 2015, because again, unbeknownst to the father and unbeknownst to his counsel, they received a check, that is, she received a check for reimbursement of payments that he had made with regard to medical care for the child from Blue Cross Blue Shield in the approximate amount of $40,000.
How long from the time she received the $40,000 and until was it at her deposition or somewhere in discovery? her father found this out?
Both. And
Okay, well, how long was the time?
it's about
Did she
approximately
have it?
8 months.
Okay, so she received the money, put it in an account for 8 months.
Well, she kept it longer than that, but she had it in an account until we discovered it for 8 months.
Okay.
What actually happened is I filed in April of 2016, I filed this petition for contempt that we're here on today. It was not disclosed at that time. I did subpoena Blue Cross Blue Shield at some point in time and receive records from them. And then I did take her deposition shortly thereafter in August of 2016, in which she admitted that she did receive the check. She didn't know the exact amount of the check. She stated there under oath that she intended to keep the check. She thought it was hers. So again, not until there was a hearing in December of 2016 when the judge discussed this check as a result of filings that were made in circuit court. And then not until March, when an order was entered, was the deposit made into the registry of the court of this amount of money. That's the keystone to what we claim is her willful and intentional violation of the parenting plan, which was part of an order in connection with the final decree, in which she was obligated to pay 50% of the uncovered medical bills. The father had advanced all of these payments to the tune as determined by the expert that's referenced in Exhibit C to the trial, Exhibit 12 to the trial proceeding. And specifically, Exhibit C to that Exhibit 12 is he paid approximately $178,000 for medical care and medical treatment.
Mr. Carvalho.
Like I said, was filed in April of 16. There was a hearing in December of 16.
Carvalho, let me ask you a question. Did
Sure.
she express any ability that she could pay before these services were rendered?
No, she claims that she expressed an ability not to pay. She didn't express that until trial,
Okay.
and sometime in December.
So
She never
he was not
wrote back.
he was not aware of her financial status or situation as far as paying on these bills before the service was rendered in.
You're talking about my client? I'm sorry, I didn't hear the question. I apologize.
Your client, he was not aware of whether or not she had the ability to pay for this medical expense before these services were rendered.
He was not aware of what her financial circumstances were. He was aware that she was married and she did have insurance and she had received assets from the divorce proceeding that they had earlier.
And the other question I had was, when she received this check for $40,000, did at any time she encroach upon this money, or did she just hold it as a whole?
We don't know. We did not get her bank records. She claimed under oath that she set it aside in a savings account. And again, we never got any documentary proof with regard to that. All we got was a check that was deposited into the court with regard to that. But we never were furnished any savings account statements or anything of that sort.
Okay, thank you.
I will go back and say, with regard to her ability to pay or her inability to pay, there's no question she had $40,000 with which to pay. There's no question that the $40,000 were reimbursement of monies that my client paid. There's no question that she held on to it before we even filed the petition in April. She had it since January. There's no question she never even told us about it until such time as we took a deposition and she was under oath and I asked the question. It is for that reason we submit that it is intentional and willful that she was at least not tendering the money that my client had advanced with regard to this, that was payments for the child's medical care. That's the reason we filed the petition. But for filing that petition, we submit, we would never have known about this check.
You've used your time, Chief, Mr. Conway. You've got your time for rebuttal. We're here from the appellee.
Good afternoon, Your Honors.
Good afternoon.
Nate Kennard with Chambliss, Bonner, and Stoffel, the Chattanooga Bar, on behalf of the appellee, Sara Mossbeck. Mr. Konvalinka has focused on the question of this check that Ms. Mossbeck got from her insurer. And this is a really interesting aspect of this case. She had absolutely no obligation to retain any insurance. Yes, she did. And through her own hard work, she spent multiple meetings, multiple phone calls, grievances with her insurance. She was able to get $40,000 in reimbursements that Mr. Hoover never got. Even though he paid a company to try and get something, they weren't able to get anything. But that's not really what Mr. Konvalinka was talking about. He was talking about the details of where this money went. Well, in January, the completely unrebutted testimony is that in January of 2016, Ms. Mossbeck received these funds and she put them into a separate bank account. The unrebutted testimony is that she never spent it. She didn't touch it, that it was kept separate. In fact, her own testimony is that she felt like she was under threat, a litigation threat from Mr. Konvalinka. And it was several months before, August of the previous year, that he had sent a letter to her saying, "You're going to have to pay us money."
Did she ever let him know that she was applying for these funds and that she received those funds?
At the time, there is nothing in the record indicating one way or the other whether he was aware of it, Your Honor. There's just nothing about that particular point.
Did she let him know at any time prior to the child receiving the services that she did not have the financial means to pay her portion of it and that she had insurance on it?
Yes, Your Honor. On 2 occasions, she said this. So there were these 3 wilderness therapy programs that this child was sent to. A day or two, it's not clear, one day or the day before, a day or two before the child was sent by Mr. Hoover to this first program called Trails Carolina, Mr. Hoover came to her home and he brought with her some forms. You need to sign these. And he put a consent to treatment form. She signed that. She doesn't want to stand in the way of the child receiving the benefits that Mr. Hoover could provide. He also put in front of her a consent to payment form. Her unrebutted testimony is that she told him, "I cannot afford to do this."
The consent to the consent to payment form was to who? I mean, was it the wilderness program? Was that who provided the consent to payment form?
Yes, Your Honor. It has.
In other words, okay, I'm sorry. So she refused to sign the form committing to pay that entity that was the wilderness program.
Yes, Your Honor.
All right.
And so that's a piece of documentary evidence we can look at. We can see her signature isn't on there, and that bolsters her testimony on the stand that she told Dr. Hoover she couldn't pay. And after that, he said, "That's okay, I'll take care of it." And that this sort of similar sequence occurred again roughly 1 week before the child was transferred by Dr. Hoover from Trails Carolina to the second program called Solstice East. They had a brief phone conversation, and she again told him, "I can't afford this," and he said, "I'll take care of it." It's important that she said, "This is what happened." Her testimony was, "I can't afford this, and I've made it very clear to Hoover I can't afford this." And he was asked about this. Dr. Hoover was asked about this, and he said, the question was to Dr. Hoover, "You don't recall one way or the other ever having spoken to your ex-wife about incurring any of the expenses on behalf of your daughter?" And his answer was, "No, I don't recall."
All right, let me ask you, counsel. I'm sorry. Assume that your client told him, "I can't pay this." Assume that that's what the proof shows, that she told him, "I can't pay this." Can she just and assume that he says, "I'll take care of it"? Can they just unilaterally modify the parenting plan, which is part of the court's order, on what is child support?
Well, that's the question. Is that a modification of the parenting plan? And we would submit that it's not.
It's
And
not
there-
even, but there's no question the parenting plan puts them basically 50% responsible for uncovered medical expenses. Is that right?
It uses the term uncovered medical expenses. It does, but it also includes provisions about mediation and about the second opinion procedures. The idea being we've got a method to identify when the parties disagree about what to do, how to figure that out.
And the trial
Right.
court found that neither party undertook to do that, not just father, but mother as well. Neither one of them undertook to do that, correct?
Yes, that is what the judge found. And it's true. Ms. Mossbeck did not go to the expense of seeking a second opinion. Now, why does that matter? It's because he had told her, I'm going to take care of it. Are we going to interpret this parenting plan to require her to create a controversy when none exists? Are we going to require her to, when he says, I want to do this, she says, I can't pay. There's no way I can pay for that. He says, I'll take care of it. Should she then have to go get a second opinion, incur that cost, hire a doctor to say $160,000 in wilderness therapy programs may be a little bit unnecessary. That may be too much. Maybe some of this is medical expenses. Maybe some of this is educational expenses. Should she have to do that when Hoover says, I'm going to take care of it? I don't think it makes sense to do that. Under the trial court's reading, his conclusion was that she could have avoided $99,000 in medical expenses that were denied for being medically unnecessary. He says she could have avoided that because she could have gotten a second opinion. In other words, what the trial court was saying is that she had to go get a second opinion. And that if that second opinion differed in any way from whatever it was that Hoover wanted to propose, she had to prevent Hoover from incurring it. And if we're interpreting the plan to mean that any medical expense that Hoover incurred on the child's behalf, she has to pay half of it, then she has to prevent him from spending it in the first place.
Well,
What if
let
he
me
just
ask
says,
you, Campbell.
"What I wanna do?"
She consented to treatment.
Yes,
She
Your Honor.
signed that form. She consented to treatment. Okay.
Yes, Your Honor.
All right. Before your time goes, let me ask you about the $40,000. A couple of things on that. Did your client testify that she thought it was her money and she could keep it?
No, Your Honor, that she.
What did she say in her deposition?
So there was a
I kind of
confusing.
paraphrased what Mr. Konvalinka said. So
Yeah, his statement was she said she intended to keep the check. There is no statement like that anywhere in her deposition. She was asked during her deposition about whether she was entitled to receive the proceeds. And her answer at that time was yes, though Mr. Konvalinka didn't follow up on that. When she was subsequently asked about it and had an opportunity to explain, she made clear that I didn't think that that I could keep the check as mine, go and spend it. I mean, if she did, wouldn't she have then gone and spent it? She didn't
Why
do
did she
that.
hold on? Why did she hold on to that money for so long then, without
Your Honor,
telling him?
I don't know the answer to that question. I believe that she was waiting to figure out what was ultimately going to be the adjudication over this issue of, who should owe what. And frankly, that's what the trial court.
Did she say why?
That's what she said. Frankly, her testimony is not entirely clear, though. What I gather from it is that the threat, and which then became the reality of litigation, is she thought, let's put this into an account and keep it there until we know what's supposed to be done with it.
All right. She knew, as I understand it, she knew it was for reimbursement.
Yes.
That kind of implies somebody's paid something if you're being reimbursed, correct?
Yes, Your Honor.
And she knew she hadn't paid.
Yes.
So she knew the person who paid, that she was received this money for reimbursement, was the father.
Ultimately, that because of the expenses he incurred, that is why the insurer sent her that reimbursement check.
So the answer to the question is yes.
Well, yes. I mean,
Okay.
Her testimony was that she never intended to keep it. She testified that that she never thought that it was, something for her to spend. She just didn't know quite what to do with it at the time. And under Mr. Konvalinka's theory, she was under what he contends, that she is willfully in contempt because she didn't just pass that check on to him. But the trial court didn't do that either. When the trial court says, let's put that money into the court's account. And then when I figured out how it's going to be apportioned, then I'll distribute it. And that's what the trial court did. It didn't pay the money to Hoover immediately either. And there's also the additional question, she can't be willfully in contempt if she just couldn't afford to pay it. And the trial court's finding on that point was she can't afford to pay it.
I have a question about that. I've kind of wondered, meaning I don't know the answer. Let's assume we find that she should have paid the $40,000 on to the father, but that's all she could have paid. And that was less than the amount found even by the trial court, I guess, before it did all credits and everything. Would it be willful contempt if she could pay only a portion of what she was supposed to pay and didn't?
I don't think so, Your Honor. I don't think that she knew. It's got to be clear and unambiguous what she's supposed to do. That's the standard for contempt, right? And
Mr. Convalinka proved that to me several years ago, that the Supreme Court said that it had to be clear.
Right.
And
what we have here is what I would only describe as an utterly convoluted set of circumstances about, how much Dr. Hoover is owed if anywhere close to the $180,000. I mean, he himself couldn't keep track of it. At one point, at different periods, he claimed that he had spent $190,000, $178,000, $181,000. And he was never able to identify the amount of reimbursements that he received from the insurers. I mean, I don't know exactly how it is that Ms. Mossbeck, a layperson, not a doctor that makes $500,000 a year like Dr. Hoover, is supposed to be able to sort these things through with the kind of hindsight 2020 that we, with extended effort, may be able to parse it now. The fact of the matter is, the unrebutted testimony is that when the court said he paid into the court's account, she did. And then the court distributed it as the court thought was appropriate. We've made an argument that the court allocated it incorrectly, that this should be viewed like a collateral source, that when she and her then husband, who has since not been heard of, at her then husband, when they got insurance for this child, that they should get the full benefit of that Dr. Hoover shouldn't get a free ride to the tune of half of the value of that insurance reimbursement. She wasn't obligated to have insurance, but the plan did require Dr. Hoover to have health insurance. And that's the core of our argument, that the appropriate interpretation of this parenting plan, when it refers to uncovered medical expenses, it's referring to uncovered by Dr. Hoover's insurance. So to the extent that Mossbeck was able to get a collateral source of funds to help defray the cost she may be obligated to pay, she should be encouraged for doing that. That all $40,000 of that should go to diminishing the amount she might have to owe to Hoover, not that it would be split equally. One other point, Mr. Convalinka stated that the problems in this case that began in October of 2014. And Dr. Hoover said it was shortly before the child was sent to South Carolina. Ms. Mossbeck's testimony was that the problems with this child that sort of led to her needing to go to these facilities started in August of 2014, 2 months earlier. A few other important points. At no point did Dr. Hoover keep Ms. Mossbeck apprised of how much these wilderness programs would cost. He never sent her statements. He says he never even talked with her about these potential costs. He said he wasn't even going to ask for money until he knew what insurance would pay. In fact, he assumed that insurance would pay. He just assumed it. it's a sort of cavalier attitude towards funds that someone that is wealthy can afford, but someone like Mossbeck, $26,000 a year, a special ed teacher, can't afford. Fundamentally, this case is about whether we need to interpret this plan applying basic principles that we apply when we're interpreting contracts, to interpret terms reasonably, to interpret the parties' obligations to be sensible and orderly, and to require parties to act in good faith. And with that, my time has expired, and unless the court has any further questions, I will conclude.
Okay, thank you. We'll hear from you, Mr. Comblake, in rebuttal.
Yes, specifically with regard to pages 4 and 5 of my initial brief, I quote the language that was read into the record concerning the check. It is not as described by appellee counsel. The question that's asked is posed at the bottom of page 4. I'm interested in knowing, ma'am, are you aware during the period of time between January 1, 2012 until today that you received a check from Blue Cross Blue Shield of Tennessee that was payable to your husband or you or both for the care of child during this period of time? Answer, yes. And what happened to that check? Answer, we've been saving it. Top of page 5. Question, is there any reason that you haven't paid father that money? Answer, yes. Question, why? He said that he would take care of child's medical bills. Is it a fair statement, ma'am, that you think that you're entitled to receive all of the $30,000 that's been paid by Blue Cross Blue Shield for health insurance reimbursement for the care of the child because father said he was going to take care of the bills personally? Answer, yes. This issue with regard to the secondary coverage, with all due respect to counsel, she did not carry that coverage. That coverage was through her husband, who worked for McKee Foods in connection with this. In the record, it is clear there were 2 other children. They had family coverage. It was in connection with that family coverage that this was paid. And with regard to the opportunity to explain didn't arise until the date of the hearing, sometime in the year 2018, that's outrageous. Mr. Hal North was sitting there at the deposition. If he wanted to have this woman explain she didn't really mean to keep the money, that could have been asked right then and there. It could have been filed in a pleading. Somehow we had an argument after this in December where she was still claiming she may be entitled to the money. They didn't agree to give it to my client in December of 16. They insisted upon depositing into the registry of court so they can make a determination as to whether or not she should be able to receive any of that money. And this is when we've already introduced Exhibit 2 to that proceeding, which showed, at least by my client's calculation, he was owed $178,000. An opportunity to explain? Yes, I would submit to you that when you know that you have a clear, unambiguous order that says you are obligated for 50% of the uncovered medical, whether you consider that to be medical insurance or whether you consider that to be your money, you should be at least discussing a payment to the man who has spent the money. To say that they didn't know anything about the bills, look at the exhibits that went to Missy Harris. She was given an itemization of the expenses that were incurred so that she would be aware of it at the time, and that substantial bills were still coming. That's exhibits 6 and 7. And with regard to this revisionist history, if you will, I would submit, Ms. Mossbeck, that occurred at or about the time of trial. And as the court points out, case law is fairly clear. You cannot modify that clear, unambiguous order between the 2 parties. It has to be modified by the court. And also, by reason of your question, you gleaned the argument that Mr. Hoover says when he says, I'll take care of it, was he mean he was going to take care of the insurance company? He was going to take care of the inpatient providers and that he was forgiving her all the debt? No, he was just relieving her of the obligation to pay directly to the providers at best. He didn't tell her, you don't have to pay anything. He told her not to sign the form because he would take care of it, because he knew who the insurance companies were, who the healthcare providers were going to come after anyway. And somehow, in some way, that casual conversation that they have, of course, I didn't hear any rebuttal with regard to whether or not there's any discussions with him. Have there been any discussions with Miss Raoul, who's the guardian ad litem? These parties did not get along. There was actually allegations of physical abuse of the child by the mother. They were not talking. They were not necessarily co-parenting as best we could, but that's why we had a guardian ad litem. And that's why.
Wait, let me clear one thing, make sure I understand what you said. There are allegations of physical abuse by mother.
Yes.
Who made the allegations?
My client did in his complaint, and
All
there
right.
wasn't.
That's really not here, neither here nor there in any of these issues, right?
It is not, except for the fact that I will just say, for the purposes of the record, that's just a demonstration that these parties were not necessarily co-parenting. That's the only reason.
I think we can probably accept the fact that they were not particularly getting along for whatever reason.
And with regard to the state of Tennessee, I mean, again, there's been some statements that they were not involved. I would, again, just encourage you to read the order that has been entered in this case in October. I think that's technical record 195, 196. With regard to this mediation issue, there was a parenting, there was an order entered in which it was clear that the mediation did not have to occur with regard to child support. That was excluded from going to mediation. There's this continuing harangue about the parties were obligated to go to mediation. That's not even true under the plan. They were not obligated to go to mediation with regard to the issue of child support.
Your time's expired, Mr. Convalinka.
All right.
Thanks to both sides. We appreciate your briefs and your oral argument on it. I think we have a clear understanding of both sides of the issues and both sides' positions. If you would, Madam Clerk, please recess court till 10 a.m. Eastern time tomorrow morning.
This honorable court stands adjourned.
You all have a good day.
Thank you all.
Okay.